All rise. In the Session Court of Georgetown, case number 18-08-99, Public Prosecutor against V. Primantaran Pillai.
With permission, Your Honor, I am Muhammad Amanullah bin Muhammad Rashidi, the Deputy Public Prosecutor for today. We are joined with the learned defense counsel as well, Your Honor.
With permission, Your Honor, I am Anismura binti Muazzin from Amira and Partners, representing the accused Mr. V. Primantaran Pillai.
Your Honor, as the court is well aware, today is a day for hearing. With permission, the prosecution team would like to produce the charge sheet, Your Honor. We would like to mark the charge sheet as Exhibit P1.
All right, proceed.
With permission, Your Honor, we would like the charge to be read towards the accused.
Belief, proceed.
Accused, do you understand English?
Yes, I do.
Then I shall read the charges right now. For the first charge, that you on 30th February 2021 around 12 to 5 p.m. at Complex Tun Abdul Razak, Komta, Penang Road, 10,000 Georgetown, Penang, Malaysia were found to commit an offence of personating a public servant by personating a police officer, knowing he does not hold such office to fraud a man by ordering him to pay monies where failure would result in arrest. Therefore, you have committed an offence under Section 170 of the Penal Code and punishable with imprisonment for a term which may extend to 2 years or with fine or with both under the same section. For the second charge, that you on 23rd February 2021 around 12 to 5 p.m. at Alaman Sungai Arah Sierra Residences, 11,900 Bayan Lepas Pulau Pinang, were found to commit an offence of personating a public servant by personating a police officer, knowing he does not hold such office to fraud a man to surrender money for the release of her husband. Therefore, you have committed an offence as under Section 170 of the Penal Code and punishable with imprisonment for a term which may extend to 2 years or with fine or with both under the same section. For the third charge, that you on 23rd February 2021 around 12 to 5 p.m. at Queens Bay Mall 100, Persiaran, Bayan Indah 11,900 Bayan Lepas Pulau Pinang were found to commit an offence of personating a public servant by personating a police officer knowing he does not hold such office to fraud a woman to surrender money for falsely informing her of criminal involvement and to secure such monies for her absolvement. Therefore, you have committed an offence under Section 170 of the Penal Code and punishable with imprisonment for a term which may extend to 2 years or with fine or with both under the same section. For the first charge, that you on 3rd March 2031 around 12 to 5 p.m. at 1 Jalan Mayang Pasir, Bandar Barat, Bayan Baru, 11,950 Bayan Lepas Pulau Pinang, were found to commit an offence of cheating by personating a police officer to fraud a woman to surrender money or that she may face criminal prosecution. Therefore, you have committed an offence as under Section 416 of the Penal Code and punishable with imprisonment for a term which may extend to 7 years or with fine or with both as provided under Section 419 of the Penal Code. For the fifth charge, that you on 30th March 2021 around 12 to 5 p.m. at 70-1-76 di Piazza Mall, Bayan Baru, 11,900, Pulau Pinang were found to commit an offence of cheating and dishonestly inducing delivery of property by inducing the person deceived by deception practice as sole inducement. Therefore, you have committed an offence as under Section 420 of the Penal Code, which is punishable with imprisonment for a term which shall not be less than 1 year and not more than 10 years and with whipping, and shall also be liable to fine as provided under the same section. Accused, do you understand these charges?
Yes, I understand all the charges.
Do you admit guilty or would you like to be tried for the first charge?
I plead not guilty and I would like to be tried.
Do you admit guilty or would you like to be tried for the second charge?
I plead not guilty and I would like to be tried.
For the third charge, do you admit guilty or would you like to be tried?
I plead not guilty and I would like to be tried.
For the fourth charge, do you admit guilty or would you like to be tried?
I plead not guilty and I would like to be tried.
For the fifth charge, do you admit guilty or would you like to be tried?
I plead not guilty and I would like to be tried.
Your Honor, the accused understand the charges and would like to be tried for all charges.
All right. Belief, please find a suitable time for our next hearing.
Your Honor, that would be 10 January 2023.
All right. The next case hearing would be on 10 January 2023. With that, does the prosecution team have any bail to offer to the accused?
Negative, Your Honor.
Defense counsel, do you have any bail application?
With permission, Your Honor, as a defense counsel, we would like to apply for a bail application for our client, which is not too excessive amounting 10,000 ringgit, taking into consideration of the following factors. Tuan Hakim, we appeal to this honourable court that all the offences allegedly committed by our client is available, and in our ending consent and others, if the person is charged with a bailable offence, he shall be entitled to be released on bail. Besides, it should also be noted that it also within the court discretion to allow the application for bail as per section 387 of Criminal Procedure Code. Tuan Hakim, an offence with a sentence that does not involve the death penalty or life imprisonment can be granted a bail at the discretion of the court. Hence, our client should also be given bail as all the alleged offences charged against our client do not have a life imprisonment or death penalty as punishment. Therefore, we humbly submit that our client shall be given a bail. Tuan Hakim. We also plead to this honourable court that this court can take several factors in making a decision to grant bail. The court should consider that our client is the only breadwinner and works as a petty trader with an income between 2,500 ringgit to 3,000 per month. In addition to having to support a wife and three children, if our client is detained, it will be hard for our client's family to survive, especially during this time where cost of living is rising due to the inflation and the money he's having is not enough to cater to the daily need. Other than that, Tuan Hakim, our client promised to give all of his cooperation to this case to be settled and promised not to run away by appearing at the police station to give his attendance. Lastly, on behalf of my client, Tuan Hakim, I would also like to request that the amount of bail allowed is not excessive, amounting to 1,000 ringgit, and is in line with OPT's salary as a trader. It is in line with the principle stated by the court in the case of Chong Lok Kiang against public prosecutor. The purpose of granting bail is to ensure that the accused will appear in court to answer the charges against him. Bail is not intended to be punitive, and excessive amount of bail are not required. With that, Tuan Hakim, I, on behalf of my clients, request that my client be released on bail and that the bail amount is not excessive.
All right. Prosecution team, do you have any objection?
With permission, Your Honor, the prosecution humbly submit that the bail application shall be rejected by the court, despite the offense under Section 170, 419, and 420 of the Penal Code being bailable on account of the following reasons. The case of Puan Bitisari, as stated in the case, if we were to refer to the fourth page of this High Court case of Alostar, this case referred to the landmark case of Public Prosecutor and Wee Sui Siang, which outlined among the considerations or grounds for us to determine whether bail shall be granted or not. Therefore, firstly, based on this case, we would like to argue that the accused in our current case is a businessman and he has the ability to fraud others. With his power, tactics, and connections, he is able to tamper with witnesses and evidence which are vital for this case. Secondly, if the bail is allowed, the accused will have the opportunity to abscond from the country. Since the police report was lodged a year ago, it is only now that we are able to put the accused into custody when we finally arrested him outside Kuala Lumpur. If the accused could evade detection for a year, then he may fly or escape to a different locality, perhaps Thailand, or to the states of Sabah and Sarawak, where he could continue to hide from detection of the authorities. Thirdly, the accused will commit the same offense again by taking advantage of the bail. The accused shows no remorse in his actions, as recently on Thursday on the 1st of December 2022, while being brought to the magistrate court, he attempted to attack the press media. If he's willing to do such stunt publicly, then he will have no shame in committing the same offense again. Lastly, the offense committed by the accused in this nature affects the well-being and welfare of the victims. One of the victims had lost a staggering amount of 100,000 ringgit, and any person will be devastated by this loss, both emotionally and mentally. If bail were to be allowed, we will be invalidating the sufferings of the victim and letting the accused go. If the court allows for bail, we will request from the court to impose certain conditions. This is because court has power to accept or reject bail, but with certain conditions attached as provided in Public Prosecutor Dato Mat. Therefore, we will humbly request the court to order the accused to appear before the nearest police station within his residence once a week. We will also request for the passport of the accused to be held by authorities in case if he absconds the country. In addition to the above, we humbly request from the court to impose a reasonable amount of bail at 50,000 ringgit. In Su Shok Leong and Padawa Raya, that the accused has the ability to abscond the country, and by limiting his financial abilities or alternatives, it will discourage him from absconding. Furthermore, since he has defrauded 5 different victims, which one of them lost 100,000 ringgit, the bail amount is commensurate with the gravity of the offense committed. Therefore, we humbly submit that the bail shall not be granted, Your Honor.
All right. Defense counsel, do you have any bellow is ready to pay for the bill?
Yes, Your Honor. Mr. Kapusami Krishnan, please come forward.
Your Honor, I am Kapusami.
Mr. Kapusami, what is your occupation and relation to the accused? And also, can you explain to the court how you can ensure the attendance of the accused for each of the trial in the court?
Your Honor, he is my cousin. I work as an oil and gas engineer with a monthly income of RM 15,000. The accused live with me and I can guarantee his appearance during trial.
Well, after making a consideration of the arguments provided from the both prosecution and the defense, the court hereby grants bail to the accused. Indeed, all the offences concerned is a bailable offence, thus the accused shall be released on bail. Therefore, the court had decided that the accused was released on bail in the sum of 10,000 ringgit, secured by one bailor for all the charges. The court had found that the grounds submitted by the defense counsel is sufficient to support the bail application. The court had also imposed two additional conditions on the accused, which is that the accused has to report to the nearest police stations once a week and the accused should surrender their international passport. The bail was granted to the accused based on this reason. Firstly, the nature of the offence is a bailable offence which is automatic right of the accused, which the court discretion may accept. The court had found that amount of security set is sufficient to ensure that the accused attends the court for each trial. Other than that, the court had found that the accused is not a flight risk person and bail should only be refused by way of established fact and not mere allegation that the accused may escape, since there is no evidence tendered to the court to prove the same, as ruled in Pang Yok Fo against public prosecutor. And lastly, the quantum of bail imposed is not too excessive for the accused, as it is not being given to punish the accused and was given in consideration of the accused's circumstances. With that, the court is urgent.
Thank you, Your Honor.
Thank you, Your Honor.